Brad Williams, Labor Compliance Group monthly newsletter. This one is the icing on the cake. This one is another travel and subsistence, but it's a little bit dated and it is shocking. Where we discussed Dream Builder in the waiver on the part of DIR there, then catch in regards to travel and subsistence. Again, DIR waived. Here is a very similar case, but it's dated. It goes back to 2016. The previous two examples of travel and subsistence were 2020. In this particular decision, it's almost identical, folks. It is almost an identical situation or an example. But in this case, Montez Glass was fined $495,000. It's shocking. And the provisions are almost identical to catch in Dream Builder. So I don't know. I don't know where DIR is coming up with these rulings. They go from one extreme to the other, and DIR cannot justify this in any way or shape. So hold on. This may take a little bit of parsing, but in the end, you're going to be left shaking your head. You're going to be shrugging your shoulders going, what do we do, Brad? Well, I'm not an attorney. I cannot give you legal advice. You're going to have to read these decisions. My suggestion is you just make comments galore on my YouTube channel. And maybe someone on DIR will look at this with a little common sense and going, oops, we really don't have a clue as to what we're doing. We go from one extreme to the next. So let me give you the rundown on this particular decision. Again, this is 2016 when the penalty was reviewed. This is an example where Montez Glass is in Sacramento and they had a project in San Jose. So their workers were driving back and forth. Not a big deal. Similar to the provisions in Catch and with Dream Builder, here the big argument is, what was the dispatch point? If you use the ruling that DIR used, there is absolutely no point of a dispatch area. In this particular case, the argument is Montez stated that he supposedly had an office in San Jose. So he used that as the dispatch point. Subsequently, if that's the case, there would be no travel requirement. Fine. DIR says, no, that doesn't apply. You need to pay travel for your workers driving to Sacramento to the Bay Area every day or whatever. Again, if you rest your decision on Catch and Dream Builders, it doesn't matter. DIR is basically saying travel time is not recognized based on those two rulings. So I'm a little bit confused here why Montez Glass was fined $495,000 for basically doing the exact same thing as Catch and Dream Builder. So let's get into here. On May 5th, there were some window replacements in a San Jose health center. The assessment determined by Montez Glass owed $297,000 in unpaid prevailing wages, $97,000 in penalties, and $17,900 in penalties under 1777. That means $297 is underpaid workers. $93 is because you screwed up in 1775. And look at they stretch this out to 1775 to 1813, and then 17,900. I'll get into each one of these. So on the first day of the hearing, DLSE moved to amend the assessment. They're going to play around with a little bit of numbers here, but let's get into the meat and potatoes. At trial, the parties stipulated the issues. Were the workers employed by Montez paid the prevailing wages? Were the workers employed by Montez Glass entitled to compensation for travel time and mileage? Were the workers employed by Montez correctly compensated? Did Montez properly request apprentices? Did Montez properly All right, now here's another problem with Montez. They had a civil wage penalty assessment the previous year for the exact same problem, requesting apprentices. If you have one strike against you, DIR is going to look heavily against lowering or any sympathy because you know the requirement. And then they go on because if you underpaid your workers, you're going to be subject to 1775. If you did not request apprentices, then you're going to be subject to 1813. And then if you didn't dispatch apprentices, so this is probably a 140 provision and 142. So the director finds that the workers employed by Montez Montez Glass were entitled to compensation for travel time and mileage. Why? DIR reversed this in Dream Builders and Catch, but stick Montez with a $250,000 penalty. The director also adjusts the amount unpaid wages for a variety of factors. The workers who carpooled, for workers who DLSE erroneously identify as working on this project, and workers to whom Montez provided a company vehicle and hotel accommodations near the job site. What's the difference? The language is the same. Travel is travel. The director finds that Montez Glass properly requested apprentices for the appropriate and only apprenticeship committee. All right, so again, you have to keep in mind that the workers for the state of California are not the sharpest knives in the drawer, okay? And as I've stated over and over again, about 15% of the time of these civil wage penalties, they're errors. They are significant errors. If you get a civil wage penalty assessment, one is to reconcile the numbers from DIR. Here are the facts. In June 2012, this goes way back. This is a 2016 deal, and this project is 2012, published this project. It looks like Montez was the sub. Montez Glass used glaziers following applicable prevailing rates. Okay, that's fine. Glaziers, basic hourly rate is $41 an hour. Training fund, this is all insignificant stuff. All right, it says right here, travel time and subsistence proportion of glazier states that regular employees are required to job site report more than 25 miles from the point of dispatch, as is determined by the individual, shall receive wages and benefits for all time spent traveling from the point of dispatch to the job site. Have we not read similar language? Isn't that very close to what is stated in Dream Builder? Dream Builder had a provision that said workers were required to be paid half of their going rate for travel time. The same provision applies to Catch. And there was in that subsection 6 that said their workers were entitled to pay plus $3 an hour for travel time. Now, what's the difference here? This is similar language. If Montez did not have control of their workers, then this is a moot point. Jerry McLean prepared this assessment. Okay, this is just the same old stuff. The travel time calculation sheet in Glaciers, which is drawn from master agreements, set forth the miles and travel time for Montez Glass. That's fine. This is just a normal process. You read the language and you say, well, there's travel time. We'll agree. The language is the same across the two determinations that we read about. With Dream Builders, it was operating engineers and laborers. Here it is Glacier. And there's a provision. Fine, we'll agree with that. The big issue here is Montez said their dispatch point was his office in San Jose, which he didn't have, but that should be a moot point. If the language is similar across all instances, and let's say Montez did not have control of his workers, then Montez shouldn't be subject to this provision. Again, DIR makes these radical 180-degree changes, and I hope Tony Montez listens to these 3 newsletter videos. And I hope he goes back after DIR and he contests this based on the other rulings that DIR's made. With that being said, the next few sections just go on to testify that Tony Montez really didn't have an office in the Bay Area. Who cares? If you base your understanding on the 2 Caltrans decisions, it doesn't matter where a dispatch point is. If you dispatch from Sacramento and the workers were never under the control of Montez, then there should be no underpayment of prevailing wages. Montez is going to go ahead and they're going to argue, look, I had an office. It was less than 25 miles away from the project, and what you're saying, DIR, is senseless. And they go back and forth. In the end, Section 1720 and following statutes set forth a scheme for determining and requiring the payment of prevailing wages to workers employed by public works. Okay, this is the same paragraph DIR uses as boilerplate. They're going to say you sign a public works project, you're going to be subject to Lasardia construction. Fine. That's just common language. The next 2 sections just go over the normal language. This is boilerplate language. Section 1775 is a requirement of underpayment of prevailing wages and liquidated damage. This is just common language. Let's get into the reason why Montez was fined as much as they were. The per diem wages includes travel and subsistence payments, 1773. The Director of Industrial Relations ascertains and considers the prevailing rate for the craft in the locality by reference to the applicable collective bargaining agreement. By the glaziers, public wage determination for Santa Clara, the Director adopted sections of the glaziers collection bargaining agreement for travel and subsistence payments to apply to glaziers working in Santa Clara County. The glaziers PWD provided for payment of travel and mileage from the point of dispatch in excess of 25 miles. Again, this is the same language over and over again. The travel and subsistence says one thing, DIR throws that out and says, well, if the worker is not under the control of the employer, then this shouldn't apply. They're saying one thing, they're doing something else. The glazier PWD also provides a point of dispatch. So the point of dispatch goes about, and if this is the case, then yeah, then workers are entitled to this travel time. But let's go on. In the instance, the testimony from DLSE witness, all right, this is going to go in as to determining where that dispatch point is. As I stated before, Montez said they had an office in Santa Clara or San Jose. It says that the actual location actually had a telephone, electric power, and toilet facilities, which are requirements for DIR's ruling. In order to find an office/dispatch point, you're supposed to have these minimum requirement. Well, he did, but DIR said, well, you didn't have any inventory. Again, DIR just pulled stuff out of to penalize this guy. Here, DIR goes, the colloquial about the physical elements is inapt. The director's task is to apply the plain meaning of the prevailing wage determination. Ah, really? The plain meaning. From when? Folks, I just shake my head. Why you do public works project, I don't know. But my job is to try to help you out and make sure you understand these hurdles. And these are serious hurdles. This is just unheard of. The teeter-totter of DIR, how they make these rulings is blinding. Be sure to check out my courses. Understanding DIR labor compliance rules and regulations. This is a great course, 6 hours. It covers the A to Z of DIR prevailing wages. Federal Davis-Bacon FAQs, very helpful. San Francisco local hire regulations if you're doing work in San Francisco or the surrounding area, including Berkeley, because they just implemented their local hire requirement. Take a look here. Navigating DIR websites, there's more there than you think. There really is. This is an absolute must. The DIR labor compliance course, this is a complement and you need to do both. California DIR prevailing wages, this is for individuals who are well versed in DIR but just can't remember all of the nuances. This is a handy little pocket guide, if you will. Federal Davis-Bacon Contractors Guide. If you're doing Davis-Bacon, take a look here. LCG, my consulting, I'm available. If you're doing large projects and need monitoring, I'm available for consulting. If you like this newsletter, subscribe, give me a thumbs up, and hit that like button. Now let's take a look here. The plain meaning. Again, this is the legalese side of deals. As I haven't stressed enough, I'm not an attorney, so I'm not giving any legal advice. I'm trying to interpret this stuff based on the many rulings within DIR. And there's a lack of clarity, a lack of consistency. As I keep emphasizing, especially with this travel and subsistence deal, the 2020 rulings on the part of Dream Builders and Catch, and then this huge reversal on terms of Montez, you have to contact DIR and hold them to the fire, seriously, because right now you're stuck. Here again, DIR's resting their hat on this dispatch point, and the other rulings never ever discuss that issue. Now, did DIR abuse its discretion by assessing penalties? Again, this is boilerplate, and 9 times out of 10, it's going to be no, DIR did not abuse their power. Overtime penalties is due for 3 occasions. Again, this is really not significant. It is this liquidated damages and this understanding of travel time. This liquidated damage, if you need to understand liquidated damages, you need to sign up for that California DIR labor compliance course, because I talk about this in depth. And I'm not going to go into depth here. There's no doubt that Montez Glass has substantial grounds for appealing the assessment as to wages contended were owed to these people. Additionally, Montez Glass has substantial grounds for appealing the assessment as to mileage expended by those workers in carpools. Okay, as reflected in amended. Okay, this is going to go into the rulings. No testimony testimony showed that workers were dispatched from the Santa Clara base. Again, this is DIR saying no testimony showed that workers were dispatched from the Santa Clara base. It shouldn't be an issue. If we were to look at the two other rulings, a bare contention of dispatch from the location contributes nothing to the inquiry whether Montez Glass has substantial grounds for appealing the assessment on that issue. Contention went unproven and uncollaborated, lacked supported details, and was disputed by the countervailing testimony of four workers who knew nothing of the Santa Clara. Again, DIR is resting their hat on this dispatch point, and if they're dispatched from Sacramento, and I've said this 3 times before, it's control of the worker. And then DIR goes on and says, excuse for empowering glaziers, apprentices. All right, again, this is the DAS 140, 142 issues. That's not the point here because DIR said, well, you did what you're supposed to do there, so we're not even going to go down that road. You're going to see here, DLS admitted that Montez Glass timely submitted. All right, so again, that's not the point. Findings in order. Here it said there were no grounds for waiver of liquidated damage. That's huge. And as I go through here, where's Marillion? Where is the argument here on the part of Marillion that Montez Glass was excused from employing glaziers? This is a DAS 140, 142 issue. See right here, they're going to talk about that. And I'm not going to go down that road because it was waived. But nowhere in this 14-page ruling is Marillion brought up. So I'm going to go back to catch. Up here, catch environment, right here. It says Marillion held that employees of Marillion were entitled to compensation for their travel time. Well, I've gone over this and over and again. So why in this particular case, I'm going to go back to this against Montez Glass. Where is Marillion in here? It's not. And I don't know if this is on part of Montez Glass not bringing it up, but it should have because it's travel time and the discussion of who was in charge of the workers, I think is a huge violation on the part of DIR. But this is 2012. This catch is 2020. A lot of things change over that period of time. Here's the damages. Wages due. This is the beauty of signing a DIR public works contract. Here, DIR, I'm going to give you $207,000 in penalty. I'm also going to give you $80,000. 75, here's a $494,000 penalty for what I think is an egregious error on the part of DIR. So again, I sympathize for you. If you willingly want to do a public works project, this is the crap you could possibly be subject to. Brad Williams, Labor Compliance Group. Thanks for watching. See you soon.